none, so we'll focus on the merits. Honorable Tribunal, the parties entered their business relationship with hope to establish long-standing business relationship. However, they were aware of the certain risk that may come into play during the business relationship. In order to prevent such situations, the parties have included a hardship clause. Nevertheless, the respondents tries to put the cart before the horse and convince the arbitral tribunal that it should not adopt the contract in the case at hand. Therefore, the claimant's submission will be made in suggested order by the respondent, and namely 2 points. Firstly, that the parties have impliedly chosen the law of Mediterranean to govern the arbitration clause, and secondly, that the evidence that claimant intends to submit shall be admitted by the arbitral tribunal, as it is crucial for the outcome of this arbitration. Moving to my first submission, as already pointed out by the respondent, there is no explicit choice of law regarding the arbitration clause. However, according to the 3-step test, there are certain factors which actually suggest that the parties have made an implied choice, and that choice is the law of Mediterranean. As pointed by the respondent, there is a general presumption that whenever the parties provide a choice of law clause regarding the principal contract, that is the parties' intention to have their business relationship consistent conducted in accordance with one particular law. However, also in the course of negotiations, the claimant suggested arbitration in Mediterranean. That is the claimant's place of business. That is another factor that points out that the claimant intended this very business relationship to be consistent, as in accordance with law of Mediterranean, this arbitral tribunal will be empowered to adopt the contract. With regard to the Sul-America case pointed by the respondent, it is essential to understand that the arbitral tribunal, the court in that case, decided to apply the law of arbitral proceedings, the lex arbitri, to the arbitration clause only in order to validate the arbitration clause, as application of the law of principal contract, of underlying contract, would actually make the arbitration clause not valid, and therefore the only reason why the judges concluded that it should be the law applicable to the arbitration, that the law of that the lex arbitri should be applicable, was the reason to make to serve the very purpose of the arbitration clause, that is the parties' intention to have their dispute resolved through arbitration. With regard to negative choice pointed by the respondent, the other alleged circumstance that allegedly points out that the parties have made implied choice as to the law of Danubia. As mentioned before, the parties generally intend to have their business relationship consistent, and the choice of law regarding the sales agreement and its position in the whole sales contract should be regarded as applying to the whole contract underlying between the parties. With regard to the neutrality raised by the respondent, this is the law applicable, the lex arbitri, is the Danubian law. This is the neutral choice of the parties. However, application the law of Mediterranean to the arbitration clause will not in any case infringe that neutrality, as under the Hong Kong rules, the arbitral tribunal might apply different law only with regard to interpretation, not the question of formal or substantive validity of the arbitration clause, and therefore the neutrality of the proceedings that the parties intended to establish will be.
Sorry to interrupt you. Are you suggesting that the law applicable to the arbitration agreement governs only certain aspects of the arbitration agreement, or I got it wrong?
With regard to the arbitration clause, even if the different law is applied under the Hong Kong rules, this is the interpretation that may only be affected, that the questions of the certain, such as validity, substantive or formal validity, remains, for example, under the Danubian law. However, the interpretation may be governed by the law of Mediterranean. Coming back to my submission, even if tribunal finds that the arbitration clause is governed by the law of Mediterranean as the parties, by the law of Danubia, it is still our client's position that the tribunal is empowered to adapt the contract. The parties, as I mentioned before, have included in their contract a hardship clause in order to reach an agreement with whenever certain unforeseen events occurs. Generally speaking, hardship clauses provide for three remedies, that is negotiations of the parties, contract adaptation, and termination of the contract. During the negotiations, the respondent acknowledged the claimant's need and the parties' need to adapt the contract in the case the parties cannot agree. According to Danubian arbitration law, there is a need for express empowerment of the tribunal's power to adapt the contract. However, it is not stated by the, nothing in the case file suggests that such conferral must be word for word conferral. The hardship clause, being interpreted through Article 8 of CISG, shows the party's intention to adapt the contract, and therefore the clause, the hardship clause included in the party's contract should be regarded as an empowerment for the arbitral tribunal to adapt the contract.
So there's no need to add in the arbitration agreement an express reference to this. You're suggesting that the fact that the clause 12 provides for this situation is sufficient.
Indeed, Madam Arbitrator. With regard to my my second and last submission.
Can I just stop you, sorry, with the risk of asking the same number of questions? Can you go back to the applicable law and just guide the tribunal? How would you reconcile your position with the separability of the arbitration agreement?
With regard to separability doctrine, the main objective of this doctrine is to keep arbitration clauses valid. That whenever the parties, the very purpose of the arbitration clause is to ensure that the parties will have their dispute resolved by the arbitral tribunal. Therefore, whenever there is no need to validate the arbitration clause, when there is no risk that the clause will be invalid, there is no need to have a resort to application of different law than the law applicable to the principal contract. With regard to the second submission, that is the evidence, I would like to kindly ask this tribunal to find that this evidence is crucial for the outcome of this arbitration, and also that the claimant's involvement does not in any case exclude this evidence from being admitted by the arbitral tribunal. The respondent alleged that the evidence is irrelevant to the case at hand. However, in the other arbitral proceedings, the respondent is itself seeking contract adaptation, and there is no hardship clause providing in that other arbitration for contract adaptation. The parties in the other arbitration decided to apply the ICC hardship clause, and ICC hardship clause provides for negotiations of the parties and termination of the contract. Nevertheless, the respondent in the other arbitral proceedings asked for contract adaptation based on unit droit principles, that is the very same applicable law as in the case at hand. As the law applicable to the principal contract is the same in this both arbitration, and there is another factor. There is another factor that constitutes the need for admitting this evidence. That is the fact that that is the amount which the respondent constitutes, that the respondent regards as constituting a hardship. In that other proceedings, the respondent considers 25% of price increase as constituting hardship, despite the fact that in the ICC hardship clause requires excessive onerousness of the contract, and in the case at hand, the hardship clause simply requires that the performance of the contract is more onerous. And taking into consideration the claimant's poor financial situation and the fact that the threshold is lowered by the parties, it's tailor-made by the parties, this is the only need to establish, there is the only mean to establish the respondent understanding of the amount which constitutes hardship, and therefore it is crucial as there are no other means to admit this evidence. With regard to the alleged involvement of the claimant to the way that the evidence was obtained, it must be emphasized that the claimant has received information concerning the other arbitration by accident. And that information was already leaked and breached as either the alleged computer hack of the respondent's legal system happened 3 weeks before the claimant has obtained the information concerning the other arbitral proceedings, and also if there were the 2 employees that disclosed that evidence, they were fired from the respondent's company in June 2018. Therefore, the claimant has not in any way decided to proactively seek the evidence. The claimant...
Sorry there, Councillor, I'm a little confused because I understood that you had paid a private investigator to get hold of the partial award in that case.
Mr. Arbitrator, nothing in the case file suggests that that the claimant proactively started seeking the evidence. The alleged hack or disclosure has happened before the claimant has received an information. As the claimant has immediately informed the respondent about the information it has received, the respondent responded that it happened either by a breach or by the computer hack of the legal system.
I don't think respondent is alleging that claimant itself hacked the computer systems or enticed the employees to break their confidentiality, just that it's now in receipt of information that has been obtained unlawfully. And what's your response to that?
I see your point of view, Mr. Arbitrator. However, the question of the clean hands policy is the very preliminary question, and there's a general agreement in the case law that the fact that evidence was obtained illegally does not disqualify the evidence from being admitted by the arbitral tribunal, as it is relevance and materiality of evidence that play a crucial role in determining whether the evidence should be admitted or not. As I am aware of my time, I would like to briefly conclude. and invite this tribunal to find that the parties have impliedly chosen the law of Mediterranean, and therefore the tribunal is empowered to adapt the contract, and that the evidence shall be admitted as it is crucial for the outcome of this arbitral proceedings.
Thank you, Counsel. I assume you want to make use of the minute.
Thank you. Now, it felt that the adaptation mechanism of the so-called hardship clause should be given effect. Now, it was also claimed that said that in the other proceeding, there is an ICC hardship clause that provides for negotiation and termination. In the case at hand, we have such an ICC hardship clause indeed, which should therefore also provide for termination and not for adaptation, even more as the ICC hardship clause in the case at hand had been narrowed down, or the wording of the ICC hardship clause had been narrowed down. And there might have been some proposals to adapt the contract between the negotiators. However, in the contract, there are actions that show otherwise. As I said, we have a narrowed down ICC hardship clause, and there is no remedy in the contract whatsoever that points to adaptation. And therefore, under the hardship clause, and there's no possibility to adapt the contract. Thank you.
Members of the tribunal, the fact that the parties have narrowed down the arbitration clause is indeed true. However, this was the respondent who has narrowed down the arbitration clause and never actually made an explicit explanation why this arbitration clause has been narrowed. Still, this is nothing in the course of negotiations has changed with regard to the arbitration clause, only in these surrounding circumstances. And therefore, it must be concluded that the fact that there is no explicit contract adaptation in the hardship clause is a mere and unfortunate result of the car accident that happened to the parties' representative. Thank you.
Thank you very much.